appreciate the subject uh, that is your Partnership Act 1932. So, in this case, when we are talking of this partnership, the essential is the nature of partnership and how the partnership registration is, how the partnership is formed and registration is required, and what is the relation between one partner with another partner, and what is the relationship of the partners to the third parties, and reconstitution of the firm is also very much required to be discussed. In addition to that, today in 2023, one will also appreciate the meaning of the term normally being used, that is your limited liability partnership. In short, abbreviated version, we call it as LLP. And what is the need, the scope, the advantages of LLP apart from its incorporation. As we all know that the development of business and the growth in business transactions in fact lead to the replacement of the proprietary form of business organizations with partnership enterprises. So whenever we utter the word partnership, it is a form of business organizations where you find that two or more persons they come together for jointly carrying on some business. Because in partnership, either you'll have two or at least two or more persons. What they do, they pool their resources, both resources in terms of money, resources in terms of materials, to their mutual advantage, and that is how they also share the business risk. So towards the end of 19th century, it was considered absolutely crucial to regulate the partnership form of business organizations. And this is required so as to have control the evils from spreading and also contaminating the business organizations and different mercantile transactions. So initially, we had Indian Contract Act 1872, which was governed um, by the provisions mentioned in the Contract Act 1872, and governed all aspects of the commerce, governed all aspects of the trade, uh, and the Chapter 9, Section 239 and 266 of the Act regulated the partnership business. But these provisions were not exhaustive, I would say. Many aspects remain unnoticed, many aspects remain unregulated. So this led to the necessity, the this led to the necessity, this led to the required more specific governance, and the government, in fact, took steps to regulate further. So the Chapter 9, Section 239 to 266, they are all replaced by your Indian Partnership Act 1932. So partnership, when we talk about, is a mere voluntary collective, and it has no force of law. In fact, I would say to its constitution. So the concept of partnership is that farm, when we are talking of, is not an entity, or farm is not a person in law, but you can say it is merely an association of persons, and the farm name is only, you can say, a collective name for individuals, those who have associated to form the partnership, and those who have also agreed to carry on business in partnership. So partnership arises from a contract, and therefore such a contract is governed not only by the provisions of the Partnership Act in that regard, but also by the general law of contract in such matters, where the Partnership Act does not specifically make any provisions. Now, coming to the nature of partnership, obviously, the Section 4, the Indian Partnership Act 1932, it lays down the definition which we are more concerned about, the partnership, the definition of partner, the definition of farm, and the definition of the farm name. When we talk about partnership, it is the relationship, and this relationship between the persons, those who have agreed to share the profits of the business carried on by all or any of them acting for all. So there are three aspects of partnership. One is your partners, another is your farm, and another is your farm name. So obviously the persons who have entered into partnership with one another, they're all called individually partners and collectively a firm. And the name under which the business and is very much, very much carried on, uh, and the farm in law is only a collective name of the partners of a partnership. It doesn't have a, again, I would like to repeat, a separate legal existence as is in a corporations. So obviously, while acquiring the farm name, the partner should keep in mind one thing that they do not violate the rules relating to trade name, rules relating to your goodwill. So the adopted name must not also mislead the public. The adopted name must not mislead the public or to confuse them with a farm of repute and the farm which is already in existence with a similar name. So they must not use the name implying some kind of sanction of patronage of the government also. People might think that this is something, some organization which has got some kind of association with the government. Because partnership firm cannot use the word limited as a part of its name. So if you look at the essentials of a partnership, obviously the definition which we have given already, and if we go for an examination of the definition of the partnership, which is already given in the section 4 of the act, indicates that there must be certain elements must coexist before a partnership can come into existence. So what are those elements? There must be minimum two persons, and the relationship must arise out of an agreement. Obviously, uh, the between the two or more persons to carry on a business, and the agreement that we are talking of must be to share the profits of a business, and the business must be carried on by all, and any of them acting for all. So each partner is very much liable for the acts of a firm which is done by a partner. So in this case, what we are more concerned about, that all those elements have to be seen, that the association of two persons, agreement, and the business, because the agreement should carry on some lawful business. The term business includes your trade, your occupation, your profession, everything. So business means carrying on business, that is obviously continuity or repetition of the act, but doesn't mean uh, it should be lengthy operation, even a single venture of an undertaking, if that is also continued participation of two or more persons for acquisition of gains is also considered. So sharing profit, mutual agency, and the liability of the partners jointly and Severally, they are liable to the third party for all the acts of the firm done while he is a partner. So the liability of the partner of the acts of the firm is very much unlimited. And when I say unlimited, that is the partner's private assets can also be used in case situation arises for paying of the firm's debt. Now coming to the types of partners, there are basically two categories of partners. Partners by virtue of partnership agreement, and second is partners by virtue of holding out. That is section 28. But the Act doesn't provide about uh, the types of partners, and this is all decided on the partnership contract. So the practice being made based on the extent of liability. So the different classes of partners, if we are looking for either actual, active, or ostensible partners. So such a partner, what he does, actively participates in the functioning of the business, actively participates in the management of the business. He shares its profits and he shares losses arising out of the business. He acts as an agent of other partners for all acts which is done in the ordinary course of business. And in the event of his retirement, he must give a public notice in order to absolve himself of all kinds of liabilities for the facts of other partners done after his retirement. Another type of partner is your sleeping partner. We call it as sleeping partner or otherwise known as dormant partners. So these partners, what they do, they invest money in the firm's business, they share the profits, but they don't participate in the functioning, I would say, in the functioning uh, of the business for all the acts of the firm. And such a partner can retire from the firm without giving any kind of public notice to this effect. So his liability for the acts of the firm ceases soon after his retirement. So such type of partners has no duties to perform, but entitlement is there to have access to the books and accounts of the firms, and he can have a copy. I would say he can have a copy of the books and the accounts of the firm. Similarly, another partner is your nominal partner. And when we are talking of nominal partner, such a partner neither invests nor participates, neither invests in the business nor participates in the management of the firm. But what he does, only gives his name to the business, only gives his name to the firm. So, however, such a partners, such partners, they are all liable to the third parties for all the acts of the firm. Unlike, as I told you, a sleeping partner, they are known to the outsiders as partners in the firm, whereas they are not actually. So they are very much required to give a public notice at the time of being separated from the firm if at all they decide. Another type of partner, partners in profit only. So in that case, a partner who is entitled to share in the profits of a partnership firm, and that too without being liable to share the losses, is called a partners in profits only. So that's a person who has sufficient, I would say, capital, but is not prepared to take risk, may be admitted to the partnership by the other partners. And in spite of his specific position in the firm, he continues to be liable to the third parties for all the acts of the firm, just like other partners. Similarly, you have sub partners where a partner agrees to share his profits in the firm with a third person, and the third person is called a sub partner. So obviously, the sub partner is not a partner in the firm, I must tell you, but he is a partner of a partner. So a sub partner has no rights. A sub partner has no duties towards the firm, and he does not carry any kind of liability for the debts of the firm so created over a period of time while running the business. So he can neither participate in partnership business nor check the accounts of such partners and claim share. Also, uh, he cannot bind the firm or other partners by his acts. So the only right he has to establish to share the profits in property at the time of winding off of the farm. So another type of partner is your partner by extopel, or otherwise we call it as by holding out. If a person by his act, if a person by his words gives another person the reason to believe that he is a partner in the firm when actually he is not, and the other person takes action on those set of facts, then in that case, such a person is extopelled. Such a person is extopelled, and later on denying the liabilities for the acts of the firm. So thus it is legally binding partnership, but that may occur where previously no formal partnership agreement was in place. So person, such person is called partner by extopel or by holding out, and he is liable to all the third parties. Similarly, when the firm declares the person to be a partner when actually he is not, we know, and that person is declared to be represented, to be represented, to be a partner in a firm. So obviously, he doesn't deny the fact that he is a partner, and such a person known as partner by holding out. So this is an active partner who fails to give public notice at the time of retirement and is also liable as partner by holding out. So now a question will arise that if we are considering a minor for the partnership firm to take him as a partner, so what is the position of a minor as a partner? Obviously, if you are taking the name of minor, minor is admitted to the benefits of partnership. So such partnership is a contractual relationship, and the parties to contract must be competent to contract. And uh, under the law to which they are subject. So a minor is incompetent to contract, as we all know. Hence, minor cannot become a partner, but with the consent of all the partners, he may be admitted to the benefits of partnership. So at that point of time, another question arises that what is the right of minor? What are the rights of minor? Obviously, he is entitled to share of the property. He is entitled to the share of the profits, so on, profits of the farm as agreed upon. He can have access to inspect and copy any of the, you can say, the accounts of the farm. And the minor also can sue the partners for an account or for some kind of payment of his share of the property or any kind of profits of the farm when severing his connection with the farm. So the amount of his share shall be determined by valuation. Valuation made as far as possible in accordance with the rule contained in section 48. So if these are the rights of the minor, then what are the liabilities of minors? As a matter of fact, a minor is very much liable to the extent we are talking of his share in the farm. He is liable to the extent of his share in the farm. And he is neither personally liable nor is his private estate liable for the acts of the farm. He cannot be declared insolvent if the farm's debts cannot be paid out of the farm's property. So now another tricky question arises that what would be his position on attaining majority? The minor has a choice to become a partner or sever his connection from the farm. And that must happen within 6 months of his attaining the age of majority. When he comes to know of he is being admitted to the benefit of the partnership, whichever date is later, that must be taken into consideration. So he has to give a public notice if he intends to become, he has elected but not become a partner in the firm within 6 months. And if he fails to give such notice, then in that case he shall become a partner in the firm on the expiry of the said 6 months. Where such person becomes a partner, his right and liabilities a minor continue up to the date on which he becomes a partner. And he also becomes personally liable to the third parties for all the acts of the firm done so far, since he was admitted to the benefits of the partnership. So his share that we are more concerned about and the profits of the farm shall be shared to each which he was entitled as a minor. But when such a person elects not to become a partner, then what would be the rights and liabilities? Then in that case, his rights and liabilities shall continue to those of a minor, no doubt about it, under which section up to the date on which he gives public notice, and his shares shall not be liable for any kind of acts of the farm which is done after the date of the notice, and he shall be entitled to sue the partners for his share, for the share of the property, for the share of profits. So now coming to the types of partnership, because partnership may be a particular adventure, because partnership may be for a fixed period, or because partnership may be at will. So in these cases, What is more important, if we look from the duration point of view, partnership may be classified into partnership at will, section 7, and particular partnership, section 8. Now coming to the partnership at will, according to section 7 of the Act, partnership is at will when no fixed period has been agreed upon for the duration of the partnership. At will, when there is no provision which is made as to the determination of partnership in any case, because the death or the death of the partner, the retirement of the partner doesn't affect the existence of such partnership, as there is no fixed date of termination, there is no definite date of termination. So such a partnership can be resolved by any partner by giving notice, and the notice has to be given in writing to all other partners of his intention to dissolve the firm as per section 43(1). And the firm is dissolved from the date mentioned in the notice as the date of dissolution, or if no such date is mentioned as from the date of communication of the notice, that must be taken into consideration. And another type of partnership, when we are talking of that, your particular partnership, when a particular partnership we are talking of, here partnership is formed for a particular adventure. Partnership is formed for a particular undertaking, for a particular period. So such type of partnership is called as particular partnership. And I must tell you one thing, that such partnership automatically comes to an end on the completion of the venture. Such partnership automatically comes to an end on expiry of that particular period. And if the partners want to dissolve the partnership before that fixed period, it can be done. How it can be done? It can be done by mutual consent. And if the partnership that we are talking of is continued after the expiry of the term or after the expiry of the completion of the venture, it is deemed to be partnership at will. So the partnership that we are more concerned about, it is distinguished from other forms of organizations. Here you have co-ownership and partnership. If two or more persons, they own a property jointly and employ the same property in a business and share the profits, it is co-ownership, not partnership. So the main point of distinction between these two, co-ownership and partnership, when does partnership arise? Partnership always arises out of a contract. Whether that contract is expressed or that is implied, which you infer from the conduct of the parties, infer from the circumstances prevailing. But whereas co-ownership may arise from an agreement or by the operation of the law, from the status or any other way. You may be the co-heirs of a property. A partner is the agent of the other partners, but co-owners is not an agent of the other co-owners. When we are talking of partnership, it involves sharing of profits. When we are talking of partnership, it involves sharing of losses. But whereas co-ownership does not necessarily do so, because partnership cannot transfer its rights. Because in the partnership, who is the main partners? They cannot transfer their rights. They cannot transfer their interest to anyone without the consent of all other partners. But however, when we look at the co-owners, they can do so without the consent being obtained from others. Because a partner can only ask for share. What share? Share of the profits out of the properties. Whereas in case of co-owner, he can only ask for what is my division of property. Partner has a lien on the farm property, whereas co-owner doesn't. And also, we know that we have Hindu joint family farms. And the Hindu joint family farms, they differ from partnership. As I told you earlier, in case of partnership, it arises out of a contract. But in case of Hindu joint family farm, that is out of status, that is by birth in the family. Partnership is governed by the Indian Partnership Act. And when we look at Hindu joint family, that is governed by Hindu law. We saw that minor cannot be a partner, although the minor may be admitted to the benefits of the partnership. But whereas Hindu joint family, in Hindu joint family, if we come across a minor is a member from the very day of his birth. How you could be a member? By virtue of his status. But he's not personally liable. So, what I mean to say that if there will be the death of a partner dissolves the partnership, but in case of co, it doesn't. The partnership, each partner has implied authority to borrow, to bind the partner. But Hindu, only Karta or the manager, who is the head of the family. Being head of the family, he is entitled to do so. But every partner is personally liable for the debts of the farm. Hindu joint family business, only the Karta is personally liable, nobody else other than. So, it is high time to talk about how partnership is formed, how registration is being made. So if you look at the formation of partnership, as I told you, partnership comes into existence and this contract may be written, this contract may be oral, or this contract may be implied from the conduct of the parties, from the circumstances you infer, which is inferred from the conduct of the parties in the business circumstances. So according to the definition, of the partnership under Indian Partnership Act 1932, there must be an agreement. Who is involved there? There must be an agreement between the partners of a partnership firm. So to constitute a valid contract, the parties to the contract must be competent to contract. And apart from that, their consent must be obtained, which must be free. And objectives should not be forbidden by law. Objectives should not be immoral. Objectives should not be as opposed to the public policy. But however, two exceptions may be noted. As I told you, in case of minor may be admitted to the benefits of an existing partnership. Existing partnership firm. Obviously, that will happen with the consent obtained from all other partners. Secondly, with regard to the relations of partners, inter se, are that of agency, no consideration is required to create a partnership. So for which you need to go for a partnership deed. As already stated, the agreement of the partnership may be oral, but always it is advisable in writing so as to avoid any kind of future disputes which might arise. Because if you have written document, evidence will be there. And the written document that contains mutual rights, that contains mutual obligations of the partners, that is known as your partnership deed. And the deed must be stamped according to the provision of Indian Stamp Act. In addition to that also, the copy of the same must be given to each partner at the time of your registration, and the copy of the deed should be filed with the Register of Firms. So the partnership deed is not a public document. Therefore, it binds only third parties so far as they have notice of it. So in the partnership deed, you have different information to be provided, which will depend upon the circumstances, but generally the partnership deed contains certain covenants like the firm name, the date of establishment, the duration of partnership, full name, permanent address of the partners, date when each of the partner joined the firm, nature of the business, scope of the business, place of the principal place of business, what is the total capital, what is the contribution which has come from each partner, provision for further capital, provision for loans by the partners to the firm, the partners' drawings, the interest aspect on the capitals, loans, drawings, current account, salaries, commissions, profit sharing ratios of the partners, everything has to be there. Apart from the rights and the duties of the partners. And what are the different circumstances? Notice of retirement, notice of dissolution can be given by a partner. That must also, it must also contain in that partnership deed. The valuation of goodwill on retirement, valuation of goodwill on death or dissolution has to be mentioned over there. And in this case, the registration of the partnership is not mandatory when we look at India, because registration of partnership is not mandatory in India. But when you are registering with certain documents, document deed puts everything into black and white. Everything into black and white, all the intentions and the purposes of the partnership as well as the modus operandi functioning. However, it is to be noted that the registration which you are more concerned about only creates an instance or evidence of the existing partnership. And that is not a creation of legal entity. And when I'm talking of registration, registration means getting the firm registered with the register of the firm, and this registration shall be done in the area where the business is situated or proposed to be situated. So you have an application for registration, the name of the firm, the place and the principal place of the business of the firm, the name, other places where the firm carries on business, the date when each partner joined the firms, everything is there. So you have a statement, and it must be signed and it must be verified by the partners, by their agents, specially authorized in this behalf. So register on being duly satisfied, record the entry of the statements and register of the firm, what it does, then issue a certificate of registration. Now the firm is registered. The firm which is registered shall use the bracket and words registered immediately with its name. And in that case, if it's not registration, if you don't go for registration, what is the effects of registration? When we are talking of partners of the firm, then if it is not registered, they cannot sue each of the firm for any sort of right which might be as contract, which might be controlled by the partnership act. Here also partnership, the firm cannot constitute a suit against a third party. So that is why firm cannot sue, but at the same time can be sued. Would you like it? And the third party can sue the firm as well as any partner. And if it is registered, there can be sued for dissolution of the firm. There can be sued for rendering of accounts of a digital firm. There can be sued for realization of profit of a digital firm. So it is having said that, there are exceptions, no doubt about it. On registration of the firm is not the right of the parties to sue the firm or any other partner. Here are the partners to sue the firm for settlement of a digital firm. The right to sue or right to claim is set up in the value and the suit So now we talk about, we have got many partners. What is the relation of partners? We have some drawn by the partners. Identify the partners. All the partners. Also, we have slips. Partners. You have relations in the event there is no specific mention of mandatory relations. The 1970, they are all applicable because these companies are duties of a partner. Duty to indemnify the loss caused by fraud. The conduct of the business, and that is exercising mutual rights and liabilities over the property firm, apart from the profits. So in this case, what is more important, that is rights of partners, right to the agent. Like unless otherwise agreed by the partners. Right of partners in normal course is there. Right to participate in the conduct of the business, right to be consulted, right of access to books, right of legal rights of the representatives during the authorized stages. You can say right to share profits, right to interest on advances, interest on capital. In all these cases, partner can be entitled to interest on capital. Right to be indemnified by the firm for all kinds of expenses incurred over your time to your ordinary proper conduct of the business. You have right to use the property, partnership property, right to leave and retire. How you try to exercise. And when I'm talking of rights which you enjoy, you have also certain duties to perform. So what are the duties of partners? There are two types of duties. Those who envisaged in the partnership contract and those prescribed in the contract. And if you look at duties envisaged in the contract, that is your partnership contract, parts may be, you may fix by duties, but these may be expressed or declared by course of dealing. Because somebody look for easy things, nobody go for the difficult one. Duties, if we look at duties prescribed by the Act, so you have a duty of good faith. You have a duty to indemnify for any kind of loss caused by fraud, because it becomes illegal. Duty to your due diligence, proper use of the property, public property. And in this case, what is the relation of the partner to third parties? That one should know. So there are two sets of relationships. First, the relationship between partners themselves, which are all implied relations due to the rights and duties arising out of contracting partnership. And secondly, relations of partners to the third parties consist of your business carried on by one or more members of the firm, business in the name of the firm, and they are all responsible as a firm to their customers. So partners there as agents, so acting, the partners who acting has no authority to act on the firm in a manner, and the person to is dealing knows he has no authority also, doesn't know, believed him to be a partner. Because when you are talking of authority, it may be express authority, it may be implied authority. So the general scope of implied authority is that it is all limited to all that is just necessary to do the business, to run the enterprise. And it doesn't extend beyond that. So some acts which you can say implied authority to sell farm some goods, to purchase goods of the farm, to accept any sort of payment or debts due to the farm, or to engage and discharge employees, everything. And if you look at the trading farm, one which carries on business of buying and selling goods. So they have a partner. Partner has certain additional powers to borrow money of the farm's credit, and to pledge the farm's goods for the purchases. And in addition to that, also to accept more and issue negotiable instrument in the farm's name, because these are all very much required in case of a business. So it is, however, it is open to the partners by means of an express contract to the extent possible, or limit the implied authority, and the third parties will be bound by such limitations only when they have notice of such curtailment. So what is the reconstitution of a farm is said to be reconstituted? I must tell you one thing clear. When there is a change in the composition of the partnership, obviously, the constitution of the farm takes place on account of admissions, death, increment, exposure. The partnership carries on business other than the business for which it was originally formed, or when the partnership business is carried on after the expiry of that fixed term, tenure, period for the purpose. So the reconstitution involves changes in the rights of partners, in the liabilities of the partners. So how does the law cope with the change concerning partnership, and to have very clear and hygienic case? So in this case, if there is a constitution, reconstitution of the farmer, obviously what we look at the admission of the partner, we look at the retirement of the partner over a period of time. And the last aspect, that is your dissolution, the dissolution of the partnership between all the parts of the farm. That is called the dissolution of the farm. When the relation between all the members company, it is dissolution of the farm as per section 39, where there is an extension of the relationship between some of the partners only, not all. And if it is a dissolution of partnership, all these shall happen. So dissolution of a farm may or may not include the dissolution of the farm. Rather, the dissolution of the farm necessarily means the dissolution of the partnership as well. Because who are responsible for forming the partnership? It is you and me. So this dissolution of the farm can occur. There is necessarily a breaking of extinction of the relationship between all the farms of the, and in both the cases there has been closing of of the business. This is by mutual agreement or by the insolvency of all the partners, what one, or any kind of business you are going for which is illegal, or there should be notice for dissolutions. So the dissolution may be in any of the way. That means the dissolution we are talking of without order of the court, that is your voluntary dissolutions and dissolution by the court. So dissolution by agreement, where the firm may be dissolved with the consent of the parameters, with the consent of the partners, or in accordance with the contract between the partners. Because there can be another option, compulsorily making him demoralized. For that purpose, compulsory dissolution is required. The firm is compulsorily dissolved by the adjudication of all the partners or of the partners that we are more concerned about, but one is insolvent. So dissolution of the firm can take place through court if the partner becomes on sound mind, or permanent incapacity of a partner, or there has been some kind of misconduct of the partner affecting the business. It is the persistent disregard of partnership agreement by a partner, or there should be any transfer of interest, because the dissolution effect is more important. Because after dissolution, the rights and the obligations, the rights of the partners, the obligations of the partners, they also continue in all things necessary. This is being for the winding of a business, and the partners may complete unsatisfied transactions, but this authority is only for the winding of the affairs of the firm, not for new ventures. And in all these cases, another aspect we have seen that your Limited Liability Partnership Act 2008. This has been introduced in India by way of Limited Liability Partnership Bill on 12th December 2008. And it was also passed by both the houses of Parliament. Approval was given to the President of India on 7th of 2009. So in LLP Act 2008, the first schedule deals with the mutual rights and duties of the partners, as well as the limited liability partnership and its parameters where there is absence of some kind of formal agreement with respect to them. Similarly, you have got second schedule, you have got third schedule, you have got fourth schedule, and in all these cases, we have to see that who can be a partner. Partner in relation to LLP, I would say he may be any person who become a partner in the LLP, and that must be in accordance with the LLP agreements. So either you have liability partners or you have designated partners, or it is the liability of a designated partners. Because in all these cases, there are certain advantages attached to it, apart from its disadvantages. If you look at the advantage of LLP, easy to form. From the cost point of view, cost of formation, that is low. And this is legally separate entity. It has got perpetual existence. The liability is also limited. Management is flexible. But if we look at the disadvantage, one thing is that no separation of management from owner. Second thing, any act of the partner that we are talking of, without the knowledge of other partners, you may find no separate, you can make from the management and the owner. So that is why incorporation has to be seen, incorporation of LLP. So in the incorporation, as I told you earlier, that minimum two partners, individual or the body corporate will be there, digital signature certificate has to be there, LLP name, LLP agreement, registered office, everything has to be there. So with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.